Go ahead.
In any event, Your Honor, I'm Ryan Clark of the Nashville Bar. I'd like to introduce my co-counsel, Jason Hodge of the Virginia Bar, who's been admitted pro hoc vice in this case, and will be arguing for Ford Motor Company.
Okay.
Good morning, Your Honors. Jason Hodge of the Virginia Bar from Richmond, Virginia, admitted pro hoc vice in this appeal on behalf of Ford Motor Company. I'd like to reserve 3 minutes for rebuttal.
All right, sir, you may proceed.
Thank you. The issue in this case is discrete and simple. Do the 3 citations for violations of Memphis City traffic ordinances issued to co-defendant Henderson implicate the exception contained in Tennessee Code annotated section 28-3-104A2, such that plaintiff's suit, which was brought more than 1 year, but less than 2 years after the accident, is timely? Because municipal ordinance violations are civil, the answer is no. There are 2 elements from the statutory exception in play here. First, whether a violation of a municipal ordinance is a criminal charge. And second, whether the proceeding attendant to the issuance of a municipal ordinance violation constitutes the commencement of a criminal prosecution. The answer to both questions is no. And as such, the statutory exception, which is to be strictly construed, simply does not apply, and that is the end of the matter. The trial court erred in denying Ford's motion for summary judgment, and this court should rule accordingly. Faced with the reality that her suit is blatantly untimely, plaintiff tries to shoehorn the underlying facts into the exception by arguing that the conduct underlying municipal ordinance traffic violations is substantively criminal because double jeopardy could apply. This is a complete red herring. But even if plaintiff is right that the underlying conduct is criminal, and she's not, her argument only gets her halfway there. And this is because she does not acknowledge, except in passing and then only in conclusory terms, the requirement that the underlying conduct also be subject to commenced criminal prosecution against the person who caused the injury. It's clear that no such criminal prosecution commenced here, which is unsurprising, given that municipal ordinance violations and their attendant proceedings are decidedly civil. At the end of the day, then, the exception simply does not apply. Plaintiff's original complaint against co-defendant Henderson was filed more than 1 year after the accident and was thus untimely. Accordingly, the suit against Ford was also untimely, and Ford is entitled to summary judgment. Now, examining each step of this process, the pertinent authority, and plaintiff's red herring argument in more detail further reveals why the exception doesn't apply. The first question to address is whether the 3 Memphis City ordinance violations are criminal charges. They are not. The case law is legion in Tennessee that municipal ordinance violations are civil actions brought by the municipality to recover a debt. While they can result in the imposition of a fine, as occurred here with the 3 default judgments of $50 each, they are still civil. The attendant proceeding follows civil rules and procedure. The municipality's burden of proof is a preponderance of the evidence, and any appeal ultimately goes to this court, not the Court of Criminal Appeals. Simply put, the issuance of a municipal ordinance violation is not a criminal charge. And without a criminal charge, the statutory exception simply does not apply. But even if there were a criminal charge, that would not end the inquiry. The second question to address is whether the 3 Memphis City ordinance violations constitute a criminal prosecution. They do not, for the same reasons just described. Indeed, in the Allen case, the Tennessee Supreme Court expressly stated that, quote, cases involving violation of city ordinances continue to be civil in nature and are not criminal prosecutions. And likewise, without a criminal prosecution, the statutory exception simply doesn't apply. And this is exactly what the Glover and Peterson cases held, and they are on point. In both Glover and Peterson, this court determined that a violation of a municipal traffic ordinance was neither a criminal charge nor the commencement of a criminal prosecution. The panels reasoned that, quote, Tennessee courts have consistently held that municipal ordinance violations are civil matters and that violations of state statutes are criminal matters. Indeed, Glover specifically is directly on point, since it dealt with one of the exact same municipal ordinance violations as here, and it's Memphis City Ordinance 11-16-3. So even while Glover and Peterson are unreported, it's hard to imagine more on-point guidance for this case. But plaintiff never grappled with the reasoning of Glover and Peterson. Instead, she employed a complete red herring, her double jeopardy argument. Plaintiff says that Glover and Peterson were wrongly decided because they did not address the purported conclusions of a trio of cases, Waller, Miles, and Dreyer, that plaintiff contends stand for the proposition that violations of municipal ordinances are substantively criminal, and that as such, citations for them must also be criminal prosecutions. To get to this desired outcome, plaintiff asserts that because a municipal ordinance violation can implicate double jeopardy, it must be criminal. And plaintiff claims that Glover and Peterson are flat wrong because they do not address the double jeopardy angle. Setting aside plaintiff's completely unwarranted aspersions cast at Fortinet's counsel throughout this case, Glover and Peterson did not address this double jeopardy angle because it was never in play. Double jeopardy is not a concept that's superimposed onto every analysis. And even when double jeopardy should be considered, it is confined to the double jeopardy context. And in any event, when it is properly considered, it definitively does not transform the very nature of the rest of the proceedings. In fact, this court has said exactly that. In 2022, in the Metropolitan Government of Nashville and Davidson County v. Singh case, this court acknowledged that it has, quote, long been established that cases concerning the violation of local ordinances are civil in nature, end quote. And most importantly, the court explained that, quote, the application of double jeopardy prohibitions do not change the essential civil nature of the proceeding. In other words, it is plaintiff, not this court nor Ford, who is wrong. Plaintiff's case law further reinforces this reality. Starting with the Younger case, it is easily distinguishable on the facts. Younger involved a violation of the state statute, Tennessee Code Annotated, Section 55-8-136. The Younger court employed the same analytical approach as the Peterson and Glover courts, as its first step was to decide whether this was a criminal charge. And the Younger court held that it was, because a violation of a state statute, of this statute, was a Class C misdemeanor. The court then considered whether there was a commencement of a criminal prosecution. And the court answered affirmatively, because under the exception, the General Assembly had allowed for a criminal prosecution to be commenced by a law enforcement officer. And under the facts in that case in Younger, once the officer wrote the ticket for the violation of that state statute, nothing more needed to be done to initiate the criminal prosecution against the defendant. The distinction is thus apparent. Younger involved the violation of a state statute that was a Class C misdemeanor, making it a criminal charge. And because the traffic citation for violation of the state statute was a sufficient charging document to commence a prosecution for that criminal charge, the second element was met as well. Glover and Peterson, conversely, involved only municipal ordinance violations that imposed only a small fine and no possibility of jail time. And no criminal prosecution was ever commenced against the defendant in those cases. As for Miles, Dreyer, and Waller, they were all double jeopardy cases. Glover and Peterson, as just discussed, do not concern double jeopardy at all. They were concerned with, as here, whether the plaintiff timely brought a civil suit. Moreover, Miles, Dreyer, and Waller simply do not stand for the propositions for which plaintiff cites them. Starting with Waller, in that case, the city of St. Petersburg, Florida, charged a person with destruction of city property and disorderly breach of the peace. He was convicted in a municipal court and sentenced to 180 days in jail. Thereafter, the state of Florida charged him with grand larceny based on the exact same underlying conduct, and he was again convicted and sentenced to 5 years in jail. On appeal, the Supreme Court of the United States held that irrespective of whether Florida treated municipalities in the state as separate sovereigns, double jeopardy precluded a municipality and the state from prosecuting a defendant for the same crime twice. That was it. Miles, from the Tennessee Supreme Court, dealt with a scenario where the defendant was charged with a violation of a city ordinance. But the case against her was later dismissed on the merits in General Sessions Court. The government sought to appeal to the Circuit Court for a trial de novo, and the defendant invoked double jeopardy. Miles started its analysis with the proposition that municipal ordinance violations are civil. The question before the Miles Court then was whether a civil proceeding could nevertheless trigger the application of double jeopardy. And it was in that context that Miles held that violations of municipal ordinances were criminal rather than civil in substance, such that double jeopardy could be implicated. This outcome is revealing, because if plaintiff were right and municipal ordinance violations were obviously criminal based on just an evaluation of the underlying conduct, then the Miles Court's analysis wouldn't have been necessary at all. Dreyer, as this panel knows, does not stand for an independent point, but is merely a recap of the history of the Miles ruling and the subsequent Tennessee cases applying that. So it reinforces the reality that double jeopardy can apply even in the context of a civil proceeding like a municipal ordinance violation. So against this backdrop, it is Glover and Peterson, and not Miles, Dreyer, Waller, and Younger, that are relevant to the facts here. Finally, it bears repeating that the court must apply the statute's plain meaning and construe it strictly. And the statutory exception as enacted by the General Assembly, deals with what actually happened, not with what could have happened. So here, even if Henderson could have been charged with a state statutory traffic violation, he wasn't. Even if Henderson could have been the subject of a criminal prosecution, he wasn't. Even if double jeopardy could have been in play for Henderson, it wasn't. And even if double jeopardy were in play, it would have been limited to protecting Henderson from serial punishment, nothing more. So in summary, this appeal has no disputed material facts. It presents a pure question of law for the court to review de novo. So it is appropriate for this court to make a fresh determination regarding whether the requirements of Rule 56 have been satisfied. And Ford has shown that they have. The court has already held that municipal ordinance violations are not criminal charges and not criminal prosecutions, such that the statutory exception to the statute of limitations does not apply. And the court should do so again by ruling in Ford's favor and entering an order reversing and remanding with instructions to the trial court to enter judgment for Ford. And that's all I have. I'll reserve the rest of my time for rebuttal.
Let me ask you, in connection with Mr. Henderson's conduct in driving, do you concede that it could have been charged as a state offense, which would make it criminal?
I believe it could have been. I think the officer testified that he could have, but he didn't. And as I mentioned, the statute and the exception is to be strictly construed and needs to deal with what actually happened. And here the officer chose to charge with a municipal ordinance violation, which is civil. And the Glover and Peterson cases addressed that issue and rejected the so-called mirroring argument. Just because a municipal ordinance violation might mirror the same conduct as a state statute, they're not interchangeable. And there are some other cases that Glover cited that also stand for that proposition.
Okay.
Thank you.
May it please the court, I'm Brian Brooks. I'm from Greenbrier, Arkansas, but I am a Tennessee attorney
All right, sir.
and have been for longer than I can remember. When I picked up this case and started reading the opinions that Ford cites and that Glover and Peterson cite, my first thought was to contact the attorneys who had brought me into the case at the trial court to help them with this issue and say, we're in trouble. There's no place to go here. But then I reflected back on the notion that, number one, if Mr. Henderson had failed to pay the fine, he would go to jail. Number two, if Mr. Henderson had failed to sign the citation, he would go to jail. He would not be subject to a civil collection action like we just saw in the case before us, where there would be liens or foreclosures or enforcement actions. The penalty is criminal. He goes to jail. And I said to myself, there must be more to this history than initially meets the eye with the review of the cases that everybody depends on. So I said, let's trace this back. Let's look at the history. Let's see where this notion that a municipal charge is civil and a state charge is criminal comes from, and where does that lead us? And one place that took me was to the O'Haver case from 1909 or 1906, somewhere in that vicinity. And what happened there was Montgomery was charged with violation of a municipal statute for failing to put a granolith sidewalk to the curb. Now, I have to tell you, I had to look up what a granolith is and found and educated myself as to that, which is something is concrete with a granite mixed in with it. And so it's for skid resistance. He refused to do it. And when the magistrate came for him to arrest him and put him in jail for failing to pay the fine, his argument was, you can't put me in jail for failing to pay a municipal fine because it's civil. And he lost that argument. And in losing that argument, the Tennessee Supreme Court told Montgomery, yes, there are civil aspects of a municipal charge. The procedure for how you get through the court is civil. But the nature of the charge and the nature of the penalty is criminal. You're arrested as if a criminal charge is made. You can be forced into labor to work off the fine like it's a criminal charge. And you can spend time in jail like it's criminal, and therefore it is criminal in nature in that respect. And the court noted those two situations, that dichotomy, that there is a civil nature to the procedure that directs how the case proceeds through the court system, and there's a criminal nature that directs the penalty. So where does O'Haver take us? The only thing I knew to do at that point in time was to shepherdize O'Haver and start reading all the cases that talked about it. And where did that take me? Where that takes us is to the double jeopardy cases. And I beg to differ with the way the wording is. My colleague from Virginia says that we argue that it's a criminal charge or criminal in substance because double jeopardy applies. That's not what my position is. My position is that double jeopardy applies because the charge is criminal in substance. It's the other way around. It's not double jeopardy directs that it's criminal. It is that it's criminal directs that double jeopardy applies. And so what we find in these cases is that the court says the charge for a municipal violation is criminal in substance. That's why when the officer arrests or cites somebody for a municipal violation and they refuse to sign the citation, they get handcuffed and taken to jail. We have cited those statutes in our briefing and in the work to the trial court. That's why if you don't pay the citation, you don't get a civil collection action filed against you like we saw in the case before us. You go to jail. They're criminal in substance. Where does the civil come in? Miles and Dreher and the other cases that we cite talk about this. The civil aspect is the procedures for migrating the way through the court. That's why, for example, if you want to appeal a charge for a municipal violation, you appeal to this court rather than the Court of Criminal Appeals. That's where the civil aspect comes in. But in all respects, the charge remains a criminal charge in substance. And because it is criminal in substance, everything that was talked about in Glover applies here. Initiating the criminal charge is done by the citation and following through with the citation to the court charge. That's why it is a criminal charge and a criminal prosecution, which meets the elements of the statute. Judge McGee, your opinion for the court in Dreher, am I saying that right? Is it Dreher? That case talked about all of the history of the double jeopardy cases, and it recaps that history quite well. What is consistent in that history is that the charges for municipal violations are criminal in substance, therefore double jeopardy applies. Not double jeopardy applies, therefore they are criminal in substance. That's, I think, a critical distinction between what we're trying to point out and the response to what we're trying to point out. If they were not criminal in substance, double jeopardy would not apply. And because they're criminal in substance, they are criminal charges and criminal prosecutions. And when there's a criminal charge and a criminal prosecution against the person who caused the injury, which in this case is Mr. Henderson, then we have the 2-year statute of limitation coming into effect. That is the sum and substance of what our argument is and what the cases say. And they say those things for the reasons that we talked about throughout the briefing and that I pointed out this morning in this argument. That is where Ford and the plaintiff part ways and part company on the logic of the cases. Now, I can stand here and keep saying that over and over, or I can do what I did the last time in this building and say, I've said what I have to say and I'll be happy to answer any questions, or I can quit early. Justice Kirby was in this court at that period of time and gave me a judicial thumbs up, which I took as a hint to sit down and shut up, which I will do if the court has no questions.
So what do you say we do about Glover and Peterson?
Glover and Peterson, that's why I went through the history of how I got to this point in making this argument. I have read the briefing in Glover and Peterson. I've read the opinions in Glover and Peterson. Nobody made this point out. Nobody pointed out to this court in either case that, look, we've got this issue out here that arises, I think, the first time in O'Haver, where the court talks about there's a civil element to the municipal charge, but there's also the criminal substance to the municipal charge. Nobody made that argument. The courts don't go find things that lawyers don't point out. So the way to handle Glover and Peterson is to distinguish them because of the arguments that are made that arise beginning with O'Haver, follow through Miles, work their way in Dreher, and come to the idea that the municipal charge is criminal in substance, therefore double jeopardy applies. That makes it a criminal charge and a criminal prosecution. That's how you handle Glover and Peterson.
Thank you for your response.
Thank you.
The trial court got this right, and I'd ask that it should be affirmed. Thank you.
Thank you, sir. Appreciate your argument. I believe you have 3 minutes left. Is that correct?
Thank you, Judge.
Yeah, 3.
So just a few quick points to hit on. My colleague on the other side mentioned that if Mr. Henderson had failed to pay the fine or sign the citation, he would go to jail. Well, that implicates the third element of the exception, which really wasn't in play and isn't in play, because it deals with what could have happened, not with what actually happened. And that third element of the exception says that the criminal conduct and prosecution must be related to the cause of action brought by the plaintiff. But putting Mr. Henderson in jail for not signing the citation or not paying the fine isn't what plaintiff is bringing her cause of action on. She's bringing it on the traffic violation. And that does not put him in jail. So frankly, I think that's another red herring, and that's the same analysis the O'Haver court went in. It wasn't the underlying conduct, but it was the failure to comply after the fact. Talking about the conceding that it's a civil procedure point and municipal ordinance violations follow civil procedure, I think that brings in some unintended consequences that aren't really considered. Because if that's the case, and the case law in Tennessee, again, says that municipal ordinance violations and their procedure are civil, taking plaintiff's position and having a criminal charge adjudicated under civil rules and procedure would end up with any proceeding, even the initial one, potentially resulting in a criminal charge being levied upon someone under a civil framework, including the preponderance of the evidence standard, and that's just contrary to law. And my last point is that plaintiff argues that the criminal takes issue with the way their argument was presented, and that it's the criminal conduct. Because it's a criminal conduct and criminal charge, that directs that double jeopardy applies. I think that's just plainly refuted by the cases, especially the Myers case that says double jeopardy has recently been decided to apply to civil proceedings and municipal ordinance violations. And the Sink case I cited says that as well. So that's all I have, unless your honors have any further questions.
I see none.
Thank you, your honors.
Thank you. Thank you, counsel. We will take this matter under advisement and attempt to get you an opinion as quickly as possible. You may be dismissed. Folks, we're going to take a short recess for a moment.